calls the matter of Morgan versus Villa, case number 2021-5545-DP. All parties and attorneys could please state their name and appearance for the record, starting with the plaintiff's attorney, Mr. Norg.
Thank you. Good morning, Your Honor. Attorney Benjamin Norg, I'm here on behalf of Mr. David Morgan, who is present. I'm covering for Ms. Tara Sharp.
Next, Ms. Granzo, you'll put your appearance on.
Yes, Your Honor. Jennifer Granzo, Assistant Prosecuting Attorney, appearing in this matter on behalf of the state of Michigan.
And Ms. Villa, are you here to represent yourself?
Yes, sir.
Good morning, everyone. Today's date and time set for a hearing. Due to the pandemic decisions of the Supreme Court and Chief Judge, we are handling this matter by remote technology. The contents of this video may be the official record of a proceeding of the state of Michigan's 9th Judicial Circuit. Unauthorized duplication, distribution, or alteration of said content is strictly prohibited. Today's date and time set for a motion filed April 16th. It's with two very distinct issues. Number one, the motion for paternity testing, and secondly, temporary parenting time. Ms. Granzo, I believe, is here just for the paternity testing. We'll start with that one. Where are we at with this matter? I'll ask the attorneys and Ms. Villa. Ms. Granzo, where are we at with regards to the paternity testing?
Well, Your Honor, just to give the court a little bit of background, this is a privately filed paternity action that did not emanate from the prosecutor's office. We have not been involved in, nor did we plan to be involved in, the paternity testing components of this case, since the parties are being represented by private counsel or on their own. They are responsible for their own costs and fees in this matter. I did briefly review the documents that were filed by Ms. Sharp's office. It does appear to me that this is a child that was born out of wedlock, having been born November 27th of 2015. There was a prior marriage for Ms. Villa, but that marriage was severed, or divorce was finalized in Van Buren County in September of 2011, well before the conception and birth of this child. And to my knowledge, there's been no other marriage by Ms. Villa since that date and time. So the question as to standing to proceed, I think, is clear. The Paternity Act in and of itself, under MCL 722.714, says that the movant may ask for paternity testing, and it is not just it's not a questionable dynamic of whether one can have the test or not. The request merely has to be made, and the test is a right that either party may proclaim. So as to the ability for the court to order DNA testing, I see nothing that would stand in the way of doing that. Now, I do understand that the mother has provided a plethora of documents and has responded to the complaint. Her focus appears to be on the fact that she believes that DNA testing that was done previously should be utilized in this case, not knowing the circumstances or the dynamics under which that test was conducted and whether or not it was done by an AABB approved lab under the supervision of lab personnel. I think it would be appropriate to do a court sanctioned test that follows the requirements of the Paternity Act itself, which would require that the testing be done by an AABB laboratory, that the chain of custody happen, and all of those dynamics, so that you have a test result that is admissible for this court with no question as to the veracity of the parties tested or the result received. And then the rest of the assertions appear to be related to parenting time in custody.
Mr. Norg, does your client want to take a test from an accredited lab?
He does, Your Honor.
Is your client able to pay the cost for that test, approximately $450?
Yes, Your Honor, he can.
Ms. Villa, do you have any problem with Mr. Morgan and your child doing a DNA test at an accredited lab?
No, sir.
Okay. then it'll be granted since there is no objection. Mr. Morgan, as stated by Ms. Granzo, has requested a test. There's no objection. It'll be done by an accredited lab. And ma'am, Ms. Villa will make the child available to have the test. Father will pay for the test. And then once we get an official test by an accredited lab, then we can go forward with where we go from there. So, Ms. Granzo, is there anything you are needed for the rest of this hearing? Because I'll have Mr. Nord write that order up that it's stipulated to.
I do not believe so, Your Honor, although I would ask that the court consider a time frame in which to have that test completed so that the parties have a goal.
Can you folks get this done within 30 days?
Yes, Your Honor.
Yes, sir.
Okay, we'll do that within 30 days.
Thank you, Your Honor.
Thank you, Your Honor.
Sooner the better. So, Ms. Granzo, we'll continue with the temporary parenting time motion, but I want to thank you for appearing. I was surprised to see it because I did think it was a private one, but it's always a pleasure with your knowledge on all things child support and paternity. Thank you.
Thank you.
You're very welcome. Have a great day.
So, Mr. Norg, I'll have you write up that portion of today's stipulated ruling. Next portion is temporary parenting time. Ms. Villa, I'm probably pronouncing that wrong. Is it Villa or Villa?
Via.
Yeah, I'm not too good at this, so I apologize, Ms. Villa. Your position on father having, Mr. Morgan having parenting time at this time, or do you want to wait for the accredited DNA testing?
At this juncture, Your Honor, I don't have a problem with Mr. Morgan having parenting time. For the last 3 years, he has had 1 day per week. However, since April 15th, he has not seen the child at all.
Okay, Mr. Norg, what are you requesting temporarily?
Your Honor. Mr. Morgan,
Yes.
do you want to inform the court what you're asking for?
Yeah, I would like to see, I have 50-50 custody with my other child, Caleb Arnold Morgan, and I would like to run those consistently with each other to develop a family time for the two of them, which is 2 days a week. It's on a 2-3-2 schedule, which is Monday. This week will be it'll be this weekend is her weekend, so it would be Monday, Tuesday of next week, and then Friday, Saturday, Sunday, and so on and so forth with that.
Ms. Villa, are you in agreement with that, or do you want to start with 1 day a week to bring back the relationship?
I would prefer 1 day since Mr. Morgan, not had overnights with our son since 2018.
He has had them since 2018?
Has not.
I haven't had them because that was what you have requested, and I agreed to it. But that is not mine. I would like to have them every night. You chose that, not me.
Okay, hold on. Sir, this is not the time to talk to her. It's very
Okay,
immature and unprofessional. You talk to
I apologize.
me. Got it?
Yep.
Okay. You are not the legal father as of today. You are entitled to 0 parenting time until we get these results. Ms. Villa is offering you 1 day a week. Now, ma'am, is that overnight or just 1 day?
That is 1 day.
Okay, what time are you thinking?
I currently do not know his work schedule. He was getting our child from 3:30, 4 o'clock until 8 p.m. on Thursdays.
Mr. Norg, does your client want to accept 3 to 8 on Thursdays, knowing that he is not the legal father, but this is something Ms. Villa is offering?
Mr. Morgan, do you work on Thursdays? What's that schedule like for you?
Yep, I work Thursdays, and I can be out as early as 3 p.m.
Okay. Yes, Your Honor, my client will.
It's summertime. Why don't we do 3:30 to 8:30? That way you get your 5 hours. 8:30 is not too late for a 5-year-old. And sir, just so you know, once we get the lab accreditation and you're deemed the father, and from the answer given by Ms. Villa and from both of you, I don't think this is going to be a surprise that you're going to be the father, but we have to go through the proper steps. At that point, this will just be a temporary order. At that point, we may have testimony and everything to order. It could go up to 50-50. It could go Ms. Villa gets more time. It could go you get more time. We don't know. I'd encourage the parties to work together. I will put on there These are just simply allegations, but there is to be no alcohol or illegal drug use by either party while the child is in their care.
Agreed.
Okay? Okay with that, Ms. Villa?
Yes, sir.
Okay, good. So that can start this Thursday, and we'll get that lab's DNA test as soon as possible. Then we'll get in here, and as Ms. Villa and Mr. Morgan and Mr. Norg through Ms. Sharp, as you feel comfortable, there may be an agreement down the road as to what parenting time will be, but this will be the temporary order of this court, okay? Because that's what's stipulated to by the parties. Any questions, Ms. Villa?
No, sir.
Any questions, Mr. Morgan?
No, Your Honor.
Any questions, Mr. Norg?
Nothing additional, Judge. Thank you.
Can you prepare the order with what's been placed on the record today?
Yes, I can.
All right. Well, good. I'm glad you folks came to an agreement that's best for the minor, and I wish you both nothing but the best of luck.
Thank you, Your Honor.
I'll set a hearing date out for the DNA while you're all here at about 45 days. I encourage you, if you guys can get in next week to do the DNA, let's get this done. It helps everybody. But I'll set it for about 45 days out. Everyone sit tight. We'll go off the record. Don't hang up. We'll get you a date to come back on a Monday. And then if it is deemed that Mr. Morgan is the father, we'll go through the proper hearing and questions, and then we'll get this matter set on schedule for custody and parenting time down the road. All right.
Thank you.
Please sit tight. We'll be adjourned. Don't hang up.